In 1789, the Founding Fathers wrote a document to help run our country. It included lots of specifics on who had what power, but on some issues it was much more vague. In 1791, the Bill of Rights clarified a few missing details, but still dissatisfied, the American people went on to add another 17 amendments to the Constitution over the course of the last 200 years or so. One issue that is filled with conflicts is privacy. It's hard for us to make decisions about privacy because as much as we all want it, the government doesn't want to lose control of what is happening in the country. Every decision and every policy is a tug of war between how much privacy the public wants to keep and how much the government needs to know. The Constitution never says anything about privacy directly. Many amendments talk about aspects of privacy, but there is no stated right to privacy or what the right to privacy might include. Because of this, laws about privacy in state or national levels are really difficult or almost impossible to debate from a constitutional stance. One such case that went all the way to the Supreme Court is Roe v. Wade. This case started in Texas in 1970 when Norma L. McCorvey wanted to get an abortion. In Texas, abortions were only legal to save the mother's life, and Norma did not have the money to travel out of state. Linda Coffey and Sarah Weddington filed a lawsuit against the Dallas District Attorney for Norma. When her case was taken, she preferred to remain anonymous, so she went by Jane Roe, because Jane Doe had already been used for a case. The grounds of the case were that Norma felt it was unconstitutional to be permitted from having an abortion. She couldn't travel, and she felt it was her right to have an abortion done by a medical professional in a sanitary room. This case made its way to the Supreme Court. The Supreme Court ruled that an abortion was in a woman's zone of privacy. They said that the states couldn't pass unnecessary laws about abortion. This then asked the question of what was considered unnecessary. The state of Texas said that the life of the fetus needed to be considered. Long debates followed.
In Texas, the woman is the victim. The state cannot deny the effects that this law has on the women of Texas.
Will they continue the marriage? Will her health improve? Will they then be at some time in the future prepared or unprepared for parenthood?
It disrupts her body, it disrupts her education, it disrupts her employment, and it often disrupts her entire family life.
But once a child is born, a woman no longer has a choice, and I think pregnancy may terminate that choice as well.
Maybe she makes her choice when she decides to live in Texas.
It was finally decided that in the first trimester, the first 3 months of a pregnancy, that it was up to the mother whether or not to terminate her pregnancy. However, in the second and third trimesters, it went up to the states. Most made it so that in the second trimester, it was only case by case, and in the third, only to save the woman's life. When this law was instituted, the lawmakers for Texas ruled for tight abortion laws. There are the same rules on differing trimesters as there were in the courtroom, and their clinics are overseen by the Texas Department of Health. Almost 25 bills went through the legislation to try to restrict abortions as much as possible, including giving unborn babies a status under the law. Their cutoff date ended up being at the beginning of the third trimester, and there were many other laws passed, such as having to tell the husband about the abortion, or only letting physicians practice abortions, and recently requiring an ultrasound before abortions. The Democrats in Texas weren't happy, and there have been many protests for expanded abortion rights. The Republicans were the majority of the state, but because of the Supreme Court case and the protests, they had to compromise some of their restrictions, such as the legal status for a fetus. They compromised within their state that the government can keep their tight laws, and the people gave their consent by electing the representatives who would support them. So what did this mean about privacy laws? Let's start by looking at what amendments were used to argue these points. There are many amendments that were used to support the right to privacy. The First Amendment gives you the right to think what you want. The third keeps you from having to house soldiers. The fourth protects your home from being searched by the police without a warrant. All of these are aspects of privacy. But because none of these specifically state the right to privacy, it was hard to be convincing. So, the lawyers brought up the Ninth Amendment, which states that any powers not stated in the Constitution go to the people. It was originally written to safeguard the rights that they couldn't explicitly state in one list. The ruling on Roe changed laws about abortions in many states, but it also set up a ruling for other lawyers to base their cases on. Many other court cases were affected by the rulings of Roe. One that came soon after was Casey v. Planned Parenthood. In 1992, a Planned Parenthood clinic in Pennsylvania sued the state government for imposing laws that made women have to jump through hoops in order to receive an abortion. These included having to notify the father, having a 24-hour waiting period, or minors having to notify their parents. The Supreme Court restated that a woman had a zone of privacy that included, quote, marriage, procreation, contraception, family relationships, child-rearing, and education, end quote. The court's decision hinged on a new principle of whether or not the laws were causing a, quote, undue burden.
Such as the undue burden test or
the undue burden standard. The undue burden standard, as I understand it,
But undue burden, the undue burden test.
This referred to whether or not the laws were unnecessarily blocking someone from having an abortion. They declared that most of the laws Pennsylvania had passed were not undue burdens. The waiting period helped people make responsible decisions, and the rule for minors notifying their guardians was declared constitutional. Having to notify the father, however, was declared unconstitutional because they were worried about women suffering abuse from upset spouses. The court also changed the first trimester rule from only being up to the mother to states being able to legislate under the condition that the laws would only be to protect the mother and not to keep women from getting abortions. This gave power to every state to legislate their own laws. It was so ambiguous that it let every state have their own argument about what is an undue burden. For example, in Virginia, which politically is a very mixed state, our lawmakers say that if you are a minor, you have to notify at least one parent or guardian and get consent from them. But a judge can excuse you from this on special occasions. But in a state such as California, a minor can have an abortion without any mention of it to their parents. Democrats tend to lean towards as open abortion laws as possible, whereas Republicans tend to lean toward restricted abortion laws. The varying Planned Parenthood laws show where compromises were made within the states. In a state like California, full of Democrats, there probably wasn't as much debate before the conclusion was reached, but here in Virginia, there were many hours spent arguing over what is right before reaching our compromise. To understand more fully what I mean, let's look at other aspects of abortion laws. In more than half of the states in the U.S., women are required to have counseling before receiving an abortion, and these sessions have specific rules on what to say and when the counseling has to happen. Other states require pamphlets to be given out. Some states even require that the clinic tell their clients that unborn babies can feel pain, or that the fetus is legally a person from the beginning of the pregnancy. And tons of states have waiting periods of different lengths. In every state using the ambiguous laws on privacy, each separate government chose what compromises to make for their state. The right to privacy isn't only about controversial issues. The landmark court cases have been for the right to an abortion, gay marriage, and access to contraceptives, but the arguments made in those courtrooms about privacy have affected rulings on many other things. One of these is whether or not the government can look at your phone data. In 2011, 4 men were arrested for robbery. The FBI was able to search their phones for data about where they had been, when one man confessed to the accusations and gave his and his partner's cell phone numbers to the FBI. There was an act called the Stored Communications Act that permitted the FBI to search phones when there's significant evidence that doing so can help the case. Carpenter was one of the men arrested, and he was convicted with the help of evidence found on his phone. He wanted the evidence taken from his phone to be nullified for being a violation of his privacy. Like Roe, he used the Fourth Amendment as an argument for privacy. He wanted to have the FBI be required to get a warrant before searching his or others' data. His case did not succeed, and the evidence from his phone stood. Although there was no compromise made, this case shows that there are more than just hot-button issues when talking about privacy. There's no easy answer to privacy disputes. All of the laws are still ambiguous, and that makes it hard to find clear lines as to what counts as privacy and what doesn't. And any issues on it can't ever be solidly stated. There are always some sort of compromise between both groups. But I can say one thing. I am sure that as long as the USA is a country, there will be arguments about privacy. The government and the people will be hashing it out for years, trying to find one law that can make everybody happy.